Can be seated. I was just going to let you get situated. And then whenever Mr. Diaz is ready, you can approach the podium.
Thank you, Your Honor. Good afternoon. May it please the court. I represent Jerry White. And in many ways, Jerry White symbolizes every Iowan's belief that the Iowa Constitution is the supreme law of the state of Iowa. But in order for that document to be the supreme law, we need to provide it with all of the tools available to protect, defend, and vindicate that document.
Okay, lean in so we can pick up your comments for our live streaming. Thank you.
Thank you, Your Honor. Why do we have a Constitution? Well, effectively, there are two reasons. One is to establish a form of governance, and this document does that. The second is to provide for a statement of rights that are possessed by the people of the state of Iowa. This court back more than a century ago said that the people are sovereign and speak through their Constitution, and when they thus speak, its mandates are binding upon all people and on the legislature, which is but one of the agencies of government. And ultimately, that document was ratified by the people. It belongs to the people. It requires that we provide all tools available to it, including not only what remedies we can provide for the protection of that document, but also who we can hold accountable when that document is violated. There's been a lot of discussion about common law versus constitutional tort law. And I've tried to figure out a way to try to explain why the Iowa Constitution is the supreme law of the land, of this state. I've thought of several things. When we talk about common law claims, they really belong to the individual that's involved. So we're talking about an individual loss and trying to justify or compensate for that individual loss. When we're talking about a constitutional tort, what we're talking about is something that affects everyone, not just that particular individual. An individual bringing a common law claim doesn't vindicate the Constitution, but somebody bringing a constitutional tort claim is vindicating that Constitution. And I thought of this analogy, and when I was first starting out, I bought a 1980 Chevette. That was my first car that I purchased. It wasn't the first car that I had. My parents gave me something even less appealing than a 1980 Chevrolet Chevette. No one would suggest that a 1980 Chevrolet Chevette would be the equivalent of a current day Lamborghini, which, by the way, I don't own. But those two have the capacity to get you from point A to point B, but they are qualitatively very different. We place value upon vehicles in that way. Why don't we place value upon the Constitution in that way? Why don't we make the constitutional tort something other than a common law tort that, because a common law tort doesn't vindicate the Constitution.
I'm actually persuaded by your argument, and let me tell you my initial reaction to your pleading is, I think you have a claim under Article 1, Section 8. I have serious doubts about your common law claims, and maybe that's a reason why you should have a claim under Article 1, Section 8.
In fact, the way I thought about it is, from a juror's perspective, if jurors sit down and panel 8 people to sit on a civil case, and they hear that the case is about a trespass, they're not going to get all that excited. They may, in fact, look for a way out. But if you tell them that this case is about vindication of a constitutional right, they're all in on that. Why? Because it belongs to everybody.
Instructed on your Article 1, Section 8 claim.
Your Honor, I know you've asked that.
I have asked you that before.
And I think you asked it in a more recent case, too, in terms of what are the elements. This is what I came up with for elements of a constitutional claim. First of all, the standard ought to be a preponderance of the evidence. That's what was discussed in Godfrey, talking about the restatement second, Section 874A. The elements, in my estimation, should be A, action or inaction by a government official, B, within the scope of their official duties, C, that results in a denial or impairment of a person's constitutional right. That denial or impairment comes from the definition of claim in the Iowa Municipal Torts Claims Act. And then there has to be a constitutional right that falls into one or more of the following categories: property rights, liberty interest, due process rights, and privacy rights, which would include a search and seizure type claim.
In the constitutional right for the jury.
I think the court has to make a determination before submitting the issue to the jury that in fact, that there is a constitutional right involved.
Question, you referenced the Constitution being the supreme law of the state, and that's where this should originate. So if you turn to Article 12, Section 1 of the Constitution, it identifies the scope of the Constitution and its effect with respect to other laws. And it says only that laws inconsistent with the Constitution shall be void. It doesn't regulate conduct of government officials. So I guess as a textual matter, what is the support for the argument that an individual officer could violate the Constitution and that a plaintiff would be entitled to damages?
Issue was hashed out in Godfrey, initially Article 1 are all the rights that are set forth. So obviously, from that standpoint, they view those as paramount because they came first. But in terms of the responsibility, is then who is responsible if not the person that violates the Constitution?
The Constitution sets forth the parameters and it provides a remedy. It says that the laws shall be void. The founders never drafted any constitutional text that indicates that there's damages remedies. We have 100 years of case law, specifically with respect to Article 1, Section 8, that says there is no damages remedy under the Constitution. And that was true until MAP. So we have 100 years of case law that rejects your claim, but you started with an originalist premise. So I want to know the originalist evidence supporting the claim.
My understanding from looking at the Godfrey case is that the court resolved that issue in Godfrey, that there is in fact the right to assert a claim under the Iowa Constitution. So I guess from my standpoint,
Looking at the Chief Justice's special concurrence in Godfrey, and he talks about the adequacy of other remedies. If I recall right, even though the Iowa Civil Rights Act did not provide punitive damages relief, the controlling opinion says that there still shouldn't be a claim because you get some relief. So in that context, why aren't the common law claims sufficient relief even if they don't perfectly mirror or give you the full scope of relief that you claim under the Constitution?
if I may, give that last part back to me, if I may. Because I've been thinking, there's several things that run through my head here.
Godfrey says that there just needs to be some other remedy, and it doesn't have to be a full remedy. And if I remember right, that case dealt with the Civil Rights Act, and there's no entitlement to punitive damages.
Under that act, correct.
The Chief Justice wrote that that was a sufficient remedy that the court should not recognize a constitutional tort that was covered by the ICRA. So if that's true, why isn't the common law remedy here sufficient under the controlling special concurrence in Godfrey?
I think part of it is context. My recollection, and I don't recall if it was the Chief Justice who made the statement, but that effectively, if we had another scenario where personal injuries involved or security, that type of thing, you might be looking at it a little bit differently. I think my comment at the beginning is that I believe that the idea that a common law claim provides adequate remedy doesn't work. I think it has to be robust. That's the only way
Is missing. You can get damages, right?
the damage is here.
A claim?
Under the Iowa Municipal Tort Claims Act, you cannot get punitive damages against the municipality.
I mean, here's the thing that occurred, like I was suggesting earlier, it does strike to me that there is just like Justice Brennan pointed out way back in Bivens, there is not really an exact congruence between common law and constitutional claims. So, for example, I have real doubts whether there was actually a trespass here. I have doubts whether there was an assault, and I have doubts whether there was intentional infliction of emotional distress, and they've cross-appealed those issues. Those are different substantive legal requirements from Article 1, Section 8. Is that a relevant consideration here, that the substantive requirements are different? Because in Godfrey, it was the same non-discrimination based on sexual orientation that was at issue, whether you were talking about the statutory claim or the constitutional claim. Substantively, it was the same prohibition.
One of the features of a common law claims is that we've developed elements for each of those over a long period of time. We haven't really developed, and I think that Justice McDonald was really pointing out, and he's pointed out in several cases, is we haven't laid out exactly what are going to be the elements and how we're going to proceed upon those elements.
That you would instruct the jury on what Article 1, Section 8 requires in a given case, just like is done in the federal courts in a Bivens claim.
To try to keep it as simple as possible, rather than, for example, I believe, I may be mistaken, but I believe with regard to assault, you have to have intent. That's not necessarily, the process here. Here is just whether or not a constitutional right was violated.
I think what you're claiming, as I read the petition, is an unreasonable seizure of Ms. White, is what it comes down to, and that was a seizure in violation of Article 1, Section 8, to force her to come outside under those conditions and those circumstances. And that strikes me, that's a different, whatever the elements of that are, they're different from a trespass, an assault, or intentional infliction of emotional distress. Those are different elements.
Obviously, we're at that stage of a motion to dismiss where we don't necessarily get to in depth on those. I think all of those common law claims, in many ways, create impediments to the ability of bringing a constitutional tort claim. But at the pleading stage, I have to plead what I think may all fit into all of these things. I don't agree that we're at that stage where we can dismiss those, but certainly they may be weaker than the constitutional tort claim. And one of the reasons why I asked for interlocutory appeal is because I think we need to resolve as many of these issues as we can, because we're getting a lot of these claims and a lot of differing opinions at the district court level. And I think we need some kind of certainty as we go forward with these claims. I don't know if I've answered your question, Your Honor, but thank you.
The district court said that municipalities are different. We've never had a Godfrey-type case of this sort, and that the district court wouldn't expand it. And the argument's made that municipalities are creatures of statute, they're made by the legislature, and that if the legislature wants to make them subject to the sorts of claims that your client makes here, it's the legislature's job to do it and not ours. What's your response to that?
One, Iowa Code Section 671-4 provides that a claim includes a denial or impairment of a constitutional right. So the legislature has provided for it in terms of the vehicle by which to do it. But this court has also said that the Iowa Tort Claims Act and the Iowa Municipal Tort Claims Act doesn't create a cause of action itself. So, but that's the vehicle by which the legislature would do that. Secondly, in Wagner, in footnote 3, there are several, there's basically a mention, the idea that the legislature is given wider berth for claims against municipalities than against the state. So for example, you can't bring an assault, battery, false imprisonment, malicious prosecution, so forth and so on against the state, but you can against a municipality. The court there in the footnote said municipal tort claims have always stood on somewhat different footing from tort claims against the state. So
Doesn't that counsel us to say that the legislature thought even harder on that point and is actually expanding claims, and that we should defer?
Iowa Municipal Tort Claims Act, it added language for the denial or impairment of a constitutional right. I think I'm past my time, Your Honor.
Conversation with Justice McDermott.
A corresponding one on the state level. So if there's anything that the legislature considered, it considered the potential for a claim against a municipality for a constitutional tort, but said you can't have that with regard to the State Tort Claims Act, excuse me, the Iowa Tort Claims Act. I don't know if I haven't answered your question, I'm happy to try to help. Thank you, Your Honor.
In a couple minutes. Ms. Craig.
May it please the court, counsel. The primary issue at stake in this appeal is whether municipalities and their employees can be held directly liable for damages under the Iowa Constitution. If they can be, this is a vast expansion of liability for municipalities that has not been explicitly authorized by the Iowa Constitution, by this court, or by the Iowa legislature.
I thought I wrote a pretty good opinion on why there shouldn't be damages claims under the Iowa Constitution without legislative authorization. And it got 3 votes. And so there are claims, constitutional claims for damages under the Iowa Constitution. Municipalities can violate the Iowa Constitution just as surely as states can. So why would there possibly be a difference?
In the state are always treated differently for liability purposes under Iowa law. There are 2 entirely different chapters of the Iowa Code.
To the fundamental issue of if they're subject to the Constitution, and the idea of God-free claims is to vindicate the Iowa Constitution regardless of whether the legislature thinks a damages claim is necessary or not. Why is a municipality any different?
Are creatures of the legislature, and I think what you're getting at, Justice Mansfield, is the underlying issue here, which is the separation of powers issue. There is not anything in the Iowa Constitution that makes damages the remedy for its violation other than the just compensation clause. And so, although you have expanded or created a constitutional damage remedy against the state, if we now sweep in municipalities into that remedy, you're expanding it even further.
Assuming the existence of the claim, which I think we have to, as Justice Mansfield says, if the theory of the claim is that the state itself can't assert sovereign immunity in response to a constitutional tort claim, how can it extend an immunity that it can't assert to its municipalities? I mean, I understand your point about them being different, but the whole theory of the constitutional tort is that the Constitution strips away the immunity. So how can it extend it when it doesn't even have it itself?
Assuming that a God-free claim is viable against municipalities, starting at that premise, although, of course, we don't concede that, I think that Chief Justice Cady's concurrence is important here. There are exceptions in the Iowa Municipal Tort Claims Act that make litigants whole that the state does not have in the Iowa Tort Claims Act.
Now you're talking about claim by claim, constitutional tort by constitutional tort. I mean, at the highest level, your strongest argument or your blanket argument is the legislature can immunize municipalities from constitutional torts. And I guess at that level, I don't understand how that could be true if this court has taken upon itself to say the state can't even immunize itself. So how can it immunize its subsidiary municipalities?
I'm not here to argue that Godfrey should be overturned, although I think that the indications are that there are reasons that Godfrey could be overturned on very principled bases, one of which is that could be viewed as violating the separation of powers by creating a remedy that the legislature has not authorized. In this case, the legislature went so far as to pass 670.14, which says that nothing in the Iowa Municipal Tort Claims Act should be construed as allowing a constitutional tort damage remedy. Before Godfrey, the common law did not recognize direct constitutional damage claims against either the states or the municipalities. Common law tort damage claims were permitted that involved acts by government officials that also may have violated a person's rights under the Iowa Constitution, such as in McClurg versus Brenton, where the trespass claim was permitted. And as I've said, Godfrey itself was only against state officials, and it did not consider whether municipalities should be held liable directly under the Iowa Constitution. I think that for this court to say also that municipalities should be held liable directly for damages under the Iowa Constitution would go against this court's opinion in Graham versus Worthington and Thomas versus Gavin, where the court explicitly stated that states and municipalities are treated differently under Iowa law, and that we can expect that result under different circumstances. And I think Justice Manfield, for example, there are situations where a municipality may be held liable under the common law, a municipal actor may, and a state actor may not be.
What do we make of the home rule statutes and the powers that the legislatures provide to, municipalities locally to decide various issues on their own? Does that change the analysis at all?
I think that, of course, the Iowa Constitution is always the supreme law of the land. I think that's something that we all agree upon. But in terms of home rule, that's yet another example of the Iowa legislature exerting its plenary power over municipalities. And it's yet another example of that the legislature is the one that should set the metes and bounds for municipal liability.
If we assume Godfrey does apply to municipalities, what's your best argument that there are adequate remedies available for Ms. White such that we shouldn't allow a direct constitutional claim?
You have to look back at the Municipal Tort Claims Act, which allows Ms. White all of the common law remedies that she would not be able to bring against the state, for example. She's bringing trespass, she's bringing intentional infliction of emotional distress, and she's brought an assault claim. And I'm not so sure that any of those claims really are different from what a Section 8 claim would look like for Ms. White. She certainly hasn't distinguished the two claims in her pleadings in any way. And so under the common law, she'll be made whole. She can't recover punitive damages against the municipality itself, but punitive damages are available against individual actors.
Allow the common law claims to proceed in this case.
Well, the common law claims in this case have a different problem, in my view, and it's that it's under the case of Tate versus Dairyfield, there's a public policy problem here. Ms. White's claims all rely upon the wrongdoing of her husband and the urgent situation that he created, which was hashed out during his OWI case, and the officers were found to have acted reasonably in that case. Her husband specifically represented to the court that he had standing to assert Ms. White's rights in that case, and said that her consent to allow the officers into the home was involuntary because of the officers' siege, as he puts it now, at her home. And the court said, no, that conduct was reasonable.
Issue raised or decided in the district court, the Tate versus Dairyfield public policy argument on the common law claims, because I don't recall seeing that there.
I'm not sure if I actually cited the Tate case, but we certainly did rely upon the circumstances of Daniel White's case being the basis for Ms. White's claim. For example, she relies upon the same facts. And there's already been holdings by the district court that the officer's conduct was reasonable and lawful. So,
Apply to Jerry White's claims, issue preclusion, even if her husband did assert her rights, how can we have issue preclusion apply where Jerry White was not a party to that prior case?
well, I'm not alleging issue preclusion. I do think that the facts of Daniel White's case are important in terms of the qualified immunity analysis that's available to the court.
I thought I heard you say that they've been established.
They've been established in the sense that Daniel White asserted Ms. Jerry White's rights, claimed that he had standing to assert her rights in the criminal proceeding. And under the Tate versus Derafield case, which talks about public policy, you can't rely on the wrongdoing of another to establish your claim, which is essentially what Ms. White is alleging in this case, that the officers came to the home.
If we just looked at the complaint, is it also your contention that the pleading itself is insufficient on its face? And I guess my difficulty with that is, so let's take the assault claim. It seems like the elements of assault have been sufficiently pleaded in this case, to me. And if there's a justification, then that's an affirmative defense that needs to be proved. And it seems like you can't really resolve it at pleading stage. So tell me why you disagree with that, if you do.
I think that starting with the IAED claim, on its face, it's up to this court to decide whether or not the conduct was outrageous or not. Here we have a case where these facts have already been run through the criminal court with Daniel White's case. And there are some selected pleadings available in the appendix. The ruling on the motion to suppress was included because Ms. White actually block quoted it in her petition.
Assault and the trespass, both of which require justification as an affirmative defense. How can we resolve that at the pleading stage?
Again, if you look at the justification, Daniel White used Jerry White as his defense, or sought to, and said that she should have been so threatened by this situation that her consent to allow the officers into their home was involuntary. And the court in the criminal proceedings rejected that argument and said no, it was. Well, I mean, for example, the Tate versus Derafield case was decided on a motion to dismiss. And I think if you look at this from a qualified immunity perspective as well, you also have a court order under 670.4a where those facts have been found. The officer's conduct has been found to be reasonable and lawful.
The motion to suppress ruling in front of me, it strikes me that it's entirely possible, if I was a trial judge, that I could on the one hand rule that Ms. White had been unlawfully seized, but also at the same time deny the motion to suppress, couldn't I? Because Mr. White doesn't necessarily have standing to complain about Ms. White's seizure. I mean, does he?
And
Discuss that in the ruling. I mean, she lets them into the house, and then at that point, there's a discussion of a series of events. So, I mean, her issue is whether she was seized. His issue is, was it okay to pursue me to the house and go into the house and then seize me after I was there with beer and so forth. Those are two separate issues, aren't they?
yes and no. They're not separate issues if Daniel White is coming into court and saying she was unlawfully seized because of the officers surrounding my home. That made her seizure unlawful. And that's what she's saying now in her civil pleadings, is I was unlawfully seized and I should be awarded damages because the officers surrounded my home. His argument for why her consent was involuntary is the same argument that we're hearing now as to why she should be able to recover damages. And the court has already said your seizure was lawful because it said the consent was voluntary. The court couldn't have said the consent was voluntary if the seizure was lawful.
Mr. Diaz's argument that constitutional torts are inherently different, and kind of the dignitary interest that people have in asserting a constitutional violation makes common law remedies inherently inadequate. I think that's kind of what he's arguing.
The Iowa Constitution is the supreme law of the land, and it leaves the type of political question about what types of causes of action we should award damages for to the legislature. So I think that there are policy considerations here that should be left to the legislature instead of the court. The fact that we are here coming up with ideas about what the jury instruction should look like. There's already been 11 certified questions to this court about Godfrey. There's apparently 4 more coming that I am aware of. These are the kinds of questions that we should leave to the legislature and not the court. The dignitary interests that are different, that, again, that's something that should be left to the legislature and not left to the court to create a remedy here. If I could just sum up, there are many paths here. I think that this court can affirm the district court's dismissal of Ms. White's constitutional claims on a number of bases. I think that the court should reverse the district court's ruling on the municipality's motion to dismiss the common law claims. Thank you.
I'd like to make one point that I didn't get to make or didn't get out of my mouth on the first go-around, and that is that Jerry White was never able to assert any of her constitutional rights. She was never charged. So she could never say, hey, what you did violated my constitutional rights. The only way she can do that is through a damages claim. I want to talk a little bit about the concept that we should leave it to the legislature. The legislature, first of all, Constitution trumps the legislature's efforts to try to minimize or immunize individuals. And one of the problems with the legislature is they will step in and try to do things like the statute that was cited by the defendants in this case. I'm trying to find the exact number. I think it's 670.4A. And the idea that we're going to allow any legislature the ability to undermine the Constitution just seems wrong. It just seems we shouldn't be going down that path. I want to touch really short on this Daniel White versus Jerry White.
The legislature has any role in setting the boundaries and the parameters on how the Constitution should be implemented, given Article 12, Section 1, which says the General Assembly shall pass all laws necessary to carry this Constitution into effect. And it's your position that the legislature should have no role in this.
Different things. I think the way I read that part of the Constitution is that they're obligated to pass those laws necessary. One of the things that is necessary here is that the people have the right to avoid unreasonable searches and seizures, for example. People have the right to all of the Article 1 rights.
IMTCA is their agreement with your position. You can assert a common law tort against municipal officers, and here's how you do it. You can assert assault and trespass and IIED as you're doing here. And that's how they've implemented the Constitution, by providing an avenue to seek redress. And you're saying that that's just not enough, and the court should just impose fiscal liability on the government as we see fit.
I think that the legislature has, as this court has found, the ability to set out the procedural aspects of how you bring a constitutional tort claim. But I think this court has said in Wagner that you don't get to immunize individuals and to undermine the Constitution by, as they did here, try to pass a law that undermines the Godfrey decision. So I think I think they have a role, but their role is to implement the Constitution. It's not to undermine the Constitution and not to immunize people from constitutional violations. Their obligation is to pass all laws necessary to implement the Constitution, which includes the right to assert a claim for constitutional tort. And that's how I interpret that. I know that there's different versions of interpreting that particular language, but I interpret it as that it is, if there's a Constitution, you have certain rights that have been set out. It is the legislature's responsibility to assure that those constitutional rights are protected, they're defended, and they're vindicated. They have the right to set out procedures, but they don't have the right to.
Actionable, right? Like Article 1, Section 1 is actionable. Article 2, Section 2. I mean, I take it that's your view, because you've asserted Article 1, Section 1 claims here, in that it's really up to this court to control the public fisc, including the state and all the municipalities in this state, and for us to decide when they should be paying claims, and the legislature has no power on that.
I didn't say that. I said the court's obligation is to assure that the constitutional rights that are set forth in Article 1 are protected, defended, and vindicated. And I think that's all I've tried to do today.
We haven't talked about this, the intentional infliction of emotional distress. Give me your elevator speech in about 20 seconds. What's outrageous? I mean, keep in mind, this bench has seen a lot of police reports. We've read a lot of busts. We've read a lot. We've seen a lot.
I guess I view that if somebody violates the Iowa Constitution, that's pretty outrageous. So that's where I start. Now, the rest of it's a matter of looking at the individual facts and circumstances, but I think if you violate the Iowa Constitution, it should be an outrage.
Fourth Amendment motion to suppress that gets sustained is going to automatically lead to intentional infliction of emotional distress?
To what parade of horrors might occur, Your Honor. All I can talk about is this individual's right to be able to assert her constitutional right, which she has not been allowed to do because she was never charged.
You may be seated. The case of White versus Michael Harkrider et al. Is hereby submitted, and the court is adjourned for the afternoon. Thank you.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.